And this might be the perfect segue into the last subject that we're going to hit tonight, I think, because we're running out of time. Patricia Knabb, I was happy to hear last week about Robert was helping the president. Thank you. I wish you could help Rittenhouse. So there's been news. I've been following it. So Rittenhouse, there was what did they do? I mean, I guess I don't understand how it happens, but they made a request to drop the charges, presented evidence of self-defense, and the prosecutor says, no mas, we're going to proceed. Just from a procedural perspective, how does that happen? Charges have already been pressed. He's already been in jail for 2 months. They've posted bond. He's released. How do they make this request to maybe rethink the fact that the evidence supports self-defense?
So it's really whether or not there's probable cause. So you have a right to bring a motion to dismiss on the grounds that the probable cause affidavit does not state a crime or does not state probable cause of a crime. And so the one they knew was a long shot because self-defense, but the probable cause affidavit included facts that would support a self-defense. And the question was, could you say that, probable cause is the lowest possible standard. It's such that it's easy. Could you interpret the evidence in a way that there's probable cause of a crime? But they had an above average argument that the affidavit itself, what was contained within it, was insufficient to show probable cause of intentional murder. And in particular, they challenged the statute, which my interpretation and other people's interpretation of that statute in Wisconsin was that a 17-year-old is allowed to have a shotgun. It's because to make it easy, so if they're going out hunting or other things, the court made an interpretation that didn't seem correct to me. But she said that now that's a problem, by the way, because that means he faces a misdemeanor charge, which could carry up to almost a year in prison. That it will be very hard to refute evidentiary wise. He did in fact have a shotgun, and he was at the time 17. And if that's illegal under the interpretation that was propounded by the prosecution and the court agreed with, then that's a problem for him for trial because it poses this exposure if he gets a bad judge who wants to whack him with a sentence, even if he's acquitted of the rest. So hopefully they'll continue to contest that. But they brought a motion to dismiss. Motion to dismiss was denied. I think it hurt that during this entire time period, the motion to dismiss was being heard, that the John Pierce and his associate made a motion to appear pro hoc vice because they're not licensed in Wisconsin. And the prosecutors objected because the prosecutors were concerned. Now, I think some of the prosecutors' motivations were to deter public criticism of them, and I think that's an illegitimate motivation. But I think they also had a legitimate motivation, which was they were concerned that Rittenhouse would have a habeas petition after the case for legal malpractice based on facts known to the prosecution at the time, which was issues involving John Pierce and his propriety as his counsel.
Okay, so and they went through and stop there for 1 second. For everyone who doesn't know, pro hoc vice is an attorney who's not licensed in a specific state requests permission to represent a client in that state for that particular file. So they get sort of special permission. And so the prosecutors objected on the basis. Now, John Pierce apparently is running into some ethical questions about the monies that he has raised for the defense of Rittenhouse. What's happened to those monies, and the fact that he has numerous creditors. And I'm pulling this straight out of Fox News. I sent you the article, Robert. I didn't understand exactly why the prosecutors are raising this question. I mean, maybe the judge can raise it on his own volition or her own volition, but why? I would expect if the prosecutors can object, they would use any basis to object. But why would they want to get the lawyer out if, in theory, it might make their prosecution easier?
Because there may be a habeas petition later that Rittenhouse had ineffective assistance of counsel, and the prosecution was on notice of the facts that developed that and still went forward without notifying the court of it.
Okay.
So that's where that is. The other thing is the prosecutors found, and I think their other objective was they consider what Pierce has been doing in the court of public opinion to be annoying and distracting and whatnot. Also, everyone I've talked to that's in the Wisconsin legal bar thought Pierce was making a joke out of the Wisconsin court system by the fact of his involvement. So and Lynn Wood as well. So there was a lot. That's where a lot of this came from. It was simmering dislike of what had happened to date. And they may think that their plea deal or something else could be got down the road if they have competent defense counsel. But essentially you're kind of under an obligation as a prosecutor if there's a glaring ethical issue to bring it to the attention of the court, or otherwise you've considered to have been waived it if you don't raise it timely. But what they detailed was interesting. Clearly, they had additional information. Apparently, there may be some ethics investigations pending against both Pierce and Wood. Apparently, the funds were never put into an attorney-client trust account, which is a violation of Wisconsin ethics. Wisconsin Professional Code of Conduct for a criminal case. You have to put the funds in trust in most circumstances for a Wisconsin state case.
Do that everywhere. I mean, then one of the first things is you receive an advance or you receive monies that's not yours or an advance on unbilled fees. It has to go into trust by law, at least in Quebec, setting up one of those trust accounts. And sometimes it has to go into a client specific trust if it's not just a general trust. So that already, the fact that that's to me mind blowing, because just so everyone appreciates this also, if the money doesn't go into a trust account, the trust account is not the attorney's money. So if the attorney gets seized, all of his assets get seized, his trust account is not part of his assets. That does not get seized by creditors. If I accidentally receive a $50,000 advance from a client and put it into my regular bank account, but not my trust, and I get seized that day, well, there's a malpractice claim against me now because they have that $50,000, even though it was never mine to begin with. So everybody really needs to appreciate that from a liability perspective. Monies in trust do not belong to the attorney. It's client money, or it goes to the bar if there's an issue. So I didn't know that the monies raised were sitting in a piggy bank. I mean, that's
correct, and apparently misdirected funds. So apparently, what happened is Rittenhouse's mother did ask for an accounting of all the money raised on their behalf, because the story was that $2 million was raised for their legal defense, at least $2 million. Another $2 million was raised for the bail. That $2 million for bail was posted, but it turns out some of the money posted for bail was money actually intended for something other than bail, and that came up afterwards. The MyPillow guy apparently was misled about what was happening with his money by Lynn Wood, and then apparently Rittenhouse's mother requested an accounting of some sort, is what the reasonable inference is, or what I've heard. And all of a sudden, Wood withdraws from the case entirely. And all of a sudden, the Fight Back Foundation is not supporting Rittenhouse now at all. He cut ties with Pierce, and Pierce is now out raising money on his own. And originally, Wood promised everybody he would have complete, total transparency, I think were his exact words. I retweeted it out recently, just in case people forgot. But and he said that he was, and this is why I have problems on other areas with Wood, is that he has he's involved with in Sandman, aside from other issues involving how that case went. The three lawyers who do almost all the work for it as partners, he ends up stiffing and does a bunch of stuff that leads them to sue him for fraud and behaving insanely. I mean, threatening wives, family members, etc. Then came Rittenhouse, where he raised a bunch of money for a case he had no experience with, didn't put the money in trust, wouldn't give it to the mother, publicly told ABC he was going to give all of it would go to Rittenhouse defense and any extra would go to the family. Then apparently when she asked about it, and when prosecutors start asking about, are these funds in trust, and apparently they're not in trust, all of a sudden he cuts bait and runs. And the only thing he says is $700,000 has been spent on his defense. Well, where's the $1.3 million extra, at least?
Well, I mean, but even
public stories,
$700,000 spent on the defense. Everyone should appreciate that already. I'm just going to bring up one chat to get this one off. I'm not reading them. Occasionally I bring up a chat and I leave it up and I don't even read it. And then whatever. Raising a chat is not approval of the chat. Yeah, no, I mean, 700,000 already spent is one thing. And then his tweet, which is, I'm going to remain active in the civil cases for Rittenhouse.
That's John Pierce, right? Pierce sets up a new fundraiser, says now it will be in trust, and it has the mom's permission. That suggests that the 1.3 or whatever, however much it was, again, he Wood never became transparent about this, so we don't know. But a lot of money that was apparently raised for Rittenhouse is now never going to go to Rittenhouse. And his lawyers are quality lawyers. The lawyers that are there now, John Pierce not going to be involved in the criminal case. Apparently, he's talking about defamation cases that they're apparently not even going to bring until after the criminal case. So it's like, why do you need money, John, for this? While he has all these creditor issues that are outstanding. But the other thing is apparently there's still going to be a need to raise money for the criminal defense itself to add. Rittenhouse, the resources were there for a dream team. And because Wood has apparently not handled the funds correctly, there is no dream team. There's a couple of good, solid lawyers, but Rittenhouse needs 6 or 7 high quality people. And I knew people that were there in Wisconsin who are willing to help out and willing to help out on the cheap. Lawyers across the country wanting to be involved and willing to help out on the cheap. And I was willing to help out and help out on the cheap. So there were plenty of people willing to be involved, and it didn't require my involvement. I didn't even get involved in saying anything publicly until a bunch of Wisconsin lawyers said, "This is crazy. You need to say something." And that's when I did. And this is about the kid. It's not about me or Lynn Wood, frankly. It's just about money was raised for the kid that didn't go to the kid, that should have gone to the kid, and it still should go to the kid. And so that's still an issue, unfortunately. But at least he's out on bail, and I'll give them credit for raising the money for that. And at least John Pierce isn't there to muck up the case in a case he doesn't understand criminally. So and Lynn Wood can't screw it up any further. But there is issues about whether the money ever went to where the donors thought it was going.
All right. I mean, and that's after 2 months sitting in jail waiting for the bail here, or the extradition hearing to get bail.
Yeah.
So the motion to dismiss the charges, they're not dropping the charges. He's going to proceed to trial. And, we'll see when the New York Times concludes its self-defense and had done a pretty decent expose on it. You presume a jury of his peers are going to come to the same conclusion, but
you would hope he could definitely, I'm sure his defense team would welcome much more resources for investigation, for jury selection, for legal writing, for legal research. I think they only received a very small portion of those funds, and the rest went wherever they went. And the second thing is Lynn Wood should give to the family all the money he raised for the family in the name of the family. And instead of, trying to pretend he's Donald Trump.
Well, it's going to be another, oh geez, I'm not going to remember. It's DeMarco, the homeless guy that they raised the money for. Someone get me the name. Remember the name. It was DeMarco was the guy's name. The homeless guy who allegedly got the lady gas, and then she raised a GoFundMe for him, and they raised $1 million, and then he sued because they weren't giving it to him, and it turns out the entire story was fabricated to raise money so they could all live off it. Whoever gets that name, I did a few vlogs on it. I just can't remember the name right now. Okay, well that's good. So the next step then, Kyle's out and about until he gets the trial. It's not going to be anytime soon.
I don't think you would want to rush to trial in a case like this. You need to develop a full investigative record, need to continue to find ways to attack the case legally, need to continue to advocate for him in the court of public opinion. So hopefully that occurs. His actual defense may need more resources to make that occur. And I don't think going through John Pierce is the effective mechanism. John should just step down from the case and let others do that. And let that ship move into more, productive waters. So that's what he needs. It's not clear whether he's going to get it, and I think he's much more at risk than people think he is. At least he's not in custody, and that's good. And credit to them for raising the money for that. It's just it wasn't in his, but that's credit to the donors. I mean, there are plenty of people willing to donate to help. So I don't necessarily give credit to people who who raise the money for other people and then apparently keep large portions of it for themselves more than what was intended or thought to be the case.
It was McClure and Bobbitt. I had to go Google the name. Okay, and now before we end this, because we do have to end this, I want to just get to a few of the locals' questions, which I said I would get to.